Well, Lords, we were in the committal application. If we could just go back, tab 9 of the core bundle, page 94. We looked at paragraph 22A, and the next element that is common to the three breaches is 22B. Mr. Deripaska procured B Finance to vote in favour of the special resolution in the circumstances where the affirmative vote of B Finance was determinative of whether the continuance would take place. Now, so far as that is concerned, just to note first, I can't find anywhere in the judgment below a ruling on that point. So one of the questions for this court is whether it's something that you feel appropriate to decide yourselves, or depending on what else happens in relation to the issues in the appeal, whether it's something that would need to go back to the commercial court for a determination. There is material in front of you to satisfy you that the vote was determinative in the but-for sense, which is how this allegation becomes relevant. And by that, what I mean is that as a matter of Jersey law, a redomiciliation cannot take place without a special resolution, which in that jurisdiction means a 2/3 majority. And that's Articles 127Q.
You need the vote in order to set the ball running.
Yes.
Question is it necessarily going to reach the goal?
Absolutely. Absolutely. So just to sort of put in place the blocks that really aren't matters of dispute. First of all, as a matter of Jersey law, a 2/3 majority is required. As a matter of fact, it is common ground that B Finance had about 54% of the shares of EN+. And so, self-evidently, if B Finance had voted against the resolution, the re-domiciliation could not have proceeded. So, B Finance voting as it did was determinative of the resolution being passed. And so that, as I say, is what we mean by saying that the procuring of that vote was determinative in the but-for sense. If that had not happened, the re-domiciliation could not have proceeded. What my learned friend says is that a number of other things also had to happen in order for the re-domiciliation to complete. And he points to the board approval, the approval of the independent board, the approval of the Jersey Financial Services Commission, and ultimately approval in Russia. And as I say, he says that those all had to happen in order for the re-domiciliation to complete, which is essentially true. Those things did have to happen. But our response, and it may or may not be convenient, but I'll just give you the page references. Our response on that in the trial is in the trial skeleton that we produced, which is now in the supplemental bundle. And I'll just give you the paragraph references and then I'll summarise the points that were made rather than reading through it. So the trial skeleton is in the supplemental bundle at tab 57 now. And the relevant paragraphs where we dealt with it are paragraph 30, which is page 441. I don't ask you to turn it up now. I was going to try and summarise what we say, but and at section F4, which is at page 452. Essentially, we say, as I've already said, that the B Finance vote was determinative of the outcome of the shareholder resolution. Without the shareholder resolution, the re-domiciliation could not have proceeded. The fact that other events might not have happened, which would have prevented the re-domiciliation from completing, doesn't alter the fact that the B Finance vote in favour satisfies the but-for test. Whether it matters, so to speak, in terms of establishing a breach of the undertakings, whether it matters that other things might not have occurred and therefore the redomiciliation might not have proceeded. Whether it matters for the purposes of establishing a breach depends upon what the allegations of breach actually are. So it's only when we get to breaches 1, 2 and 3 to see whether what is alleged by way of breach is affected by the fact, as it is a fact, that hypothetically the Jersey Financial Services Commission might not have granted its approval, or that the Russian authorities might not have accepted the redomiciliation. So the question, as I say, whether it matters only comes to light when we look at the actual content of the breaches that are alleged to see if we have established the breaches. Which brings us to the third of the common elements across all 3 breaches, which is at the top, going back to the committal application, tab 9, page 95. The effect, paragraph C, 22C, the effect of the continuance was that the shares in EN Plus secured pursuant to the undertakings and defined therein as the shares would be automatically cancelled. And all prior shareholders in EN Plus granted new shares on a one-to-one basis in a new Russian domiciled company. And secondly, that the share certificate in respect to the shares would be automatically cancelled to be replaced with the shares in the new Russian domiciled company to be in dematerialized form. This, as you are aware, is the allegation that the judge below found not proved, and just so you've got them in one place. I think the key paragraphs, we don't need to go through them, but the key paragraphs in his judgment where that conclusion is reached are paragraphs 59, 61, 69 and 71. And in order to explain why we submit that the judge was wrong, I just wanted to walk back through 22A, B and C, just so that the nature of each allegation is apparent. As I said when introducing, 22A is the allegation of what Mr. Deripaska did. That is the act or omission which constitutes a breach. 22B is an allegation about the factual significance of what Mr. Deripaska did. And paragraph 22C is an allegation about the legal consequences of what Mr. Deripaska did. Now, you will, I know, have noticed, just as a matter of form, so to speak, that the words used in 22C in inverted commas are quotes from Mr. Deripaska's own solicitor's evidence. Automatically cancelled is a quote, if you just look across to the other page, is a quote from paragraph 52 of Mr. McGregor's second witness statement. 52.3, the existing shares and share certificates in respect of Jersey domiciled EN Plus will, upon completion of the continuance, automatically be cancelled, including the share certificates in respect of the undertakings shares held by RPC pursuant to the undertakings. So that's where and why the words automatically cancelled are in inverted commas in C1, and why including the shares certificates held by RPC pursuant to the undertakings in C2 are in inverted commas. We were quoting back to Mr. Deripaska his own solicitor's evidence in relation to that. In the circumstances, it was reasonable to assume, we had thought at the time, no doubt, I wasn't appearing then, it was no doubt reasonable to assume that those assertions would not be disputed, coming as they did from Mr. Deripaska's solicitor. Nevertheless, the judge observed, he said both sides changed their positions before the trial. That's paragraph 40 of the judgment below. And he said that Mr. Deripaska's side had reneged, whatever, changed their ground, so that there isn't a cancellation. And on that basis, he said that the onus was on my client to prove that there had been a cancellation, or an automatic cancellation of the shares, and whether or not, just carrying on with the logic of what the judge's reasoning was, he said the question whether any shares in EN Plus were cancelled was a matter of foreign law, Jersey and or Russian law. He said there was no equivalent under English law to the concept of a company migration from one jurisdiction to another, as provided under Jersey and Russian law. And so it wasn't one of those cases where the English court could just assume foreign law was the same as English law. He observed that there was no expert evidence on foreign law, and as a result, he said that my clients had failed to prove their case. We submit that he is wrong, and the error can be analysed in either of two ways. Be going back to the allegation in 22C1. What is being said is that the shares in EN Plus secured pursuant to the undertakings and defined therein as the capital S shares would be automatically cancelled. The shares, as defined in the undertaking, were, as we have suggested to your lordships, 45.5 million certificated shares in a Jersey registered company. That is what the first two lines of 22C1 are talking about. It's talking about the effect on the undertakings shares of the redomiciliation. It is not making a general point of company law. And if one looks back, so if we've got this page open, if you look back to paragraph 19 of the committal application itself, it says, pursuant to section 127Q of the Jersey Companies Law 1991, the continuance of a Jersey company abroad must be approved by a special resolution. It was inherent in the committal application itself that there was a recognition that as a matter of company law, there was what is called a continuance. And that is the word used at the beginning of 22C, the effect of the continuance. So in our submission, it was quite clear on the face of the committal application that the assertion that was being made was not, as I say, a general assertion as to the effect of Jersey law or Russian law on whether or not a new corporate entity comes into existence, or whether the Russian shares can be regarded as newly issued and different from Jersey shares as a general matter of law. The assertion was, by reference to the definition of the shares in the undertaking, that the shares defined in the undertaking would disappear, be automatically cancelled, is one way of describing the undoubted fact that there were, after the redomiciliation, no certificated shares in a Jersey registered company. And that is the point we made in our trial skeleton. Paragraph, which is in the supplemental bundle, just to close off the suggestion that this is somehow a new argument. It's in our trial skeleton, which is in the supplemental bundle, tab 57, paragraph 3.2 and paragraph 66. So that if you want to see those now, the paragraph 3.2 is page 432. Where we adopt the definition excuse me, of EN plus Jersey and the Jersey shares as being the undertaking shares.
Sorry, which paragraph are you on?
I'm sorry, in the skeleton at page 432,
Yeah,
paragraph 3.2,
yeah.
it was understood by the parties in the terms of the freezing or expressly provided that Mr.
Yes.
Deripaska's blah, 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 and then accordingly, over the page, the undertakings required Mr. Deripaska to preserve a block of certificated shares in a company registered in Jersey, EN plus PLC, EN plus Jersey, which Mr. Deripaska was the ultimate beneficial owner and which were said by him to be worth 186 million, the Jersey shares. The share certificates in respect to the Jersey shares were held by his then solicitors RPC. And if we then look at paragraph 66, we say at paragraph 66, we say, once the redom had been completed, it appeared initially and rightly to be common ground that EN plus thereafter ceased to be a company registered in Jersey, the Jersey shares were cancelled, and as a result, the associated share certificates in relation to the Jersey shares became worthless. So we were asserting the correctness of the description given in the RPC letter of the 29th of May, that the effect of the redomiciliation on the undertaking shares was that they no longer existed. So our submission is that the first way of looking, so to speak, the first way of analysing the common ground that runs through these three breaches by reference to the assertion that these shares were automatically cancelled, is that it was rightly, and we'll go through the legal materials in a minute, but just to state the point of principle, it is the case that if you accept that the shares, the undertaking shares, are certificated shares in a Jersey registered company, the effect of the redomiciliation is undoubtedly that those shares no longer exist. There is, having now seen how the judge dealt with the matter, there is an alternative argument, which is that irrespective, and in a sense this comes back to, it touches on a point we mentioned in relation to the question of whether or not the B finance vote was determinative. The question whether it matters whether or not the shares were cancelled depends upon the content of the allegation of breach. Or to put the point another way around, if what we have alleged and proved constitutes a breach without having proved that any shares were cancelled, then we've proved a breach. We don't have to prove that the shares were cancelled if what has been alleged and proved without cancellation constitutes a breach.
Do you not have to prove that it was determinative? If it wasn't determinative, then a breach has no consequence.
Well, that is why I say one has to look at what the alleged breaches are in order to answer that question. Which is what we are just about to do. As I say, the first and main point we make is that what 22C is talking about, by reference to the evidence that came from the other side, is the effect on the undertaking shares of the redomiciliation. That can only be understood by reference to what the undertaking shares were, and when we look at the effect of the redomiciliation, it is quite clear that those undertaking shares no longer existed.
I wonder if it's right that if you've proved a breach, then that's enough for your purposes, even if the shares were not cancelled in the sense that Mr. Grant relies on. Doesn't that depend on what is a fair interpretation of your application notice? So if the reasonable reader of the application notice would think that cancellation of the shares in the technical company law sense, if you like, is an essential element of what you are alleging, and that therefore in order to knock out the contempt application, it's sufficient for them to prove that there was no such cancellation, then that would be enough for them to do, wouldn't it?
Well, no, with respect. Our answer is that the question as to whether or not there's a breach is not determined by the understanding of a reasonable reader. It's determined by reference to an analysis of what the undertakings mean and whether the acts or omissions which have been alleged and proved constitute a breach. If we have made, in a sense, a superfluous allegation, then we don't have to prove it if what we have alleged and proved does constitute a breach. I mean, it may not be helped by analogies, but if an allegation had been made that a transaction involved a breach of the undertaking and a conversion, and one failed to prove that the asset was converted, that wouldn't answer the question whether there had or hadn't been a breach.
And that's not your case in respect, Mr. Crowe. Because if we look at the 3 breaches that you plead, in each case, the allegation of breach is predicated upon the cancellation of the shares.
It does. I completely
so if
agree.
we look at one, I don't know if it's the second or the third sentence, the cancellation of the shares, same thing in 2, the cancellation of the shares, same thing in 3, the cancellation of the shares.
Yes, I completely accept that, Manol. Those words are there. The point I was making is the fallback argument. So our first answer is cancellation means what it means in the context in which we're talking about, the extinction of the undertaking shares. So on that basis, I'm perfectly happy to embrace the concept that one demonstrates the shares were cancelled by reference to, well, which shares we're talking about, the capital S shares. The fallback argument I'm running with at the moment is that even if one doesn't prove the cancellation, irrespective of where those words appear, it's not a question of how often they appear. If what has been alleged as the act in 22A, procuring or permitting the vote, and if the practical result of that act is that there is a breach, we do not also have to prove that the result of the redomiciliation was a cancellation. That, I mean, in a sense, I'm sort of stating a, excuse me, a self-evident truth, which is that if what we have alleged and have proved is a breach, we have proved a breach. We may also have alleged something else as well, which we have not proved, but if what we have alleged and proved is a breach, then we have alleged and proved a breach.
What is 22D doing if it is not explaining why you say the matters that you've just pleaded are a breach of the undertaking?
It is doing exactly that. It is explaining which undertaking is broken by the acts in question. The acts in question is 22A, procuring or permitting the vote. And so we then went through, and it may be convenient to do this now, we took them in the court below, and they're dealt with in the judgment below in reverse order. So we dealt with breach 3 first. And just to remind you of the basis for that, so that is if we go to the Deripaska undertaking at tab 11, and it's paragraph 4B. and he says there, I shall take all steps as are necessary to ensure that the underlying assets, being 45.5 million unencumbered shares legally owned by B Finance in EN Plus Group PLC, remain available for direct enforcement. And what is alleged in breach 3, going back to page 95, is that Mr. Deripaska, as a result of procuring or permitting the vote of B Finance in favour of the redom, failed to take all steps as are necessary, and that the vote procured and or permitted by Mr. Deripaska meant that the shares referred to in the undertaking would no longer remain available for direct enforcement. They no longer remain available for direct enforcement because they don't exist. Fairness, sorry, I don't know if this helps to meet the point that's being put. Plainly, fairness in a committal application requires the applicant to identify what he says has been done by way of a breach. And he can't ask the court to decide that something else that he hasn't alleged constitutes or contributes to the breach. But the converse is not necessarily true. Just because something has been alleged in the committal application doesn't mean that it has to be proved if what is otherwise alleged and proved does constitute a breach. So the fact that the words, the cancellation of the shares, appear in breach 3, as I say, can either means what our main case is that the shares as defined didn't exist anymore, or it can, in a sense, be regarded as a superfluous averment. And if by interpreting, as we say, the shares to mean the certificated shares in a Jersey registered company, then what we have alleged in breach 3 does constitute a breach, because Mr. Deripaska did something. He took a step, he caused or procured or permitted B Finance to exercise a voting power, excuse me, which had the result of the undertaking shares no longer existing. And just to provide a little documentary context for that, you may already have seen this, but there are just 2 documents I wanted to draw your attention to, which is why I said right at the beginning of the hearing that really the only point of foreign law is a matter of record and not a matter of any doubt. The Jersey Companies Law, Article 127V, is in the authorities bundle at tab 19. I'm sorry, different bits of the law have got scattered, but the bit we need for this is, so it's authorities bundle, tab 19, page 596. And in a sense, this is self-evident, but here it is in the statute, 127V at the top of page 596. When a company is, in accordance with the terms of the authorization of the Commission under 127U, continued as a body corporate under the laws of the other jurisdiction to which the authorization relates, it thereupon ceases to be a company incorporated under this law, and the registrar shall on that date record by virtue of paragraph A of this article, it has ceased to be so incorporated. So, stating the obvious, but migration to Russia means that EN Plus is no longer a company incorporated under the law of Jersey. And the other document we took the judge to is the notice of the EGM convening a shareholders meeting, which describes the consequences of the redomiciliation and the implications, and that is in the supplemental bundle at tab 52. Sorry, 51, I do apologise. page 365. This is extract from a 120-something page notice of the EGM. And if I just draw to your attention a couple of short passages, which again are just matters of record and cannot be sensibly disputed. Page 368. Special resolution 1 is that the application by the company to the JFSC is approved. Special resolution 2 that the application of the company to the Russian Federal Tax Service, blah, 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 for continuance as a company established under the laws of Russia be and is hereby approved. And 3, that the company alter its memorandum articles by adopting a new charter as the charter in place of the present memorandum articles with effect from the date of registration. And then over the page 369, under special resolution 4, ordinary resolution 3A, in order to proceed with the continuance of the company, that the company is authorised to allot and issue 571 million and so on ordinary shares in the capital of the company, the migration shares. The migration shares shall be issued to the existing members pro rata to their existing shareholding in the company as part of the continuation process. Page 371. There is a clear warning. If you look under Special Resolution 3, the second paragraph by the second whole bunch, you are strongly advised to review the new version of the draft charter as set out in Schedule 1 in full, as the legislation of the Russian Federation is different from Jersey law. Page 372, middle of the page. After continuance in Russia, the company is only permitted to have its registered office in a special administrative region. The company intends to move the registered office to Kaliningrad. And then you get the charter on page 375. Look at page 376. It describes the foreign legal entity, paragraph 1.1, describes the foreign legal entity, its original establishment, its transfer to Jersey, and its transfer to Russia. And then after 111, 112, 113, in connection with the said resolution, became EN Plus Group, International Public Joint Stock Company, registered in accordance with the procedure established by the laws of the Russian Federation. All of this, again, as I say, I mean, it's slightly labouring the point, but it is self-evidently the case that the effect of the migration is that what was a Jersey registered company subject to Jersey law is now a Russian registered company which has issued migration shares which are governed by Russian law, and it has its registered office in Russia. 1.4, Russian law becomes the governing law of the company. Page 378, paragraph, Article 2.5. The company's registered office is Russian Federation in Kaliningrad. Page 379, Article 6.1. The company shall, the company shall ensure maintenance and keeping of the register of the company's shareholders according to the laws of the Russian Federation. Page 380 is Schedule 4, a general description of the continuance process. Paragraph 1.6, following the continuance, a foreign company has the status of an international corporation and operates under Russian laws, which becomes the governing law of the foreign company.
Might the court read 1.4 just so I don't have to take it to the court
Certainly.
tomorrow?
Yeah, absolutely. And then over the page 381.
1.7b makes the point again.
will not.
Yeah,
create
absolutely,
a new
yes.
legal
Doesn't
entity.
create a new legal entity, indeed so. And then 381, it is as we agree, it's a continuance. That's how the Jersey law describes it too, as I acknowledge. Page 381, paragraph 3.2, in the middle of the page. Under Russian law, the migration shares are dematerialized. Jersey certificates of ownership are not valid after the migration becomes effective. 3.5, on that page, the company's continuance out of Jersey is the reason for transferring the register of members of the company from the existing registrar in Jersey to the Russian entity, which will act as a registrar. The Russian registrar will, using data contained in the Jersey register of members, open the accounts of in the Russian register. And 3.6, 1st of November 2018, the board resolved that upon registration of the company as an international corporation in Russia, the Russian register will be maintained by a joint stock company, inter-regional registration center, blah, 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 under the laws of Russia. And then finally, I think page 383, you'll see about 2/3 of the way down the page, there's a bold italicized heading, other risks of migration. And if we look at the very bottom of the page, there's a stranded heading, very last line, risk of refusal to recognize and enforce foreign court decisions and foreign arbitral awards. And 717 says that lawsuits and claims and so on, which could be brought against a foreign legal entity before the state, may be brought against the international corporation. However, 718, however, there is a risk that the Russian court may refuse to recognize and enforce foreign arbitral awards. And then a few lines below that, there is also a risk that Russian court may refuse to recognize and enforce some foreign court decisions due to the absence of international treaty.
Again, I
I
invite
see
the court to read the whole thing,
Oh, yes, absolutely.
the whole of 718, so I don't have to go to it.
I'm grateful. And
I was just going to say, before we get there, that at 714, there's a risk that Jersey authorities may not approve the migration if the requirements for continuance under Jersey law are not complied with.
yes,
But nothing is said that even if the requirements are complied with, the Jersey authorities may decide not to approve it for other reasons. It's a bit tenuous, but
yeah, I'm not sure what one, no, I'm not sure what one can make from that. But your lordships will, I don't know, either now or in due course, read the whole of 718. So, in our submission, it is clear from matters which cannot be disputed that the result of the migration is self-evidently that the company EN Plus ceases to be a Jersey registered company. It ceases to have Jersey law as the governing law of its constitution. It ceases to have a share register in Jersey, and it becomes a corporation which is governed by Russian law, with its register maintained in Russia by a Russian entity. It is the case, this was pointed out in the course of argument in the Court of Appeal the last time we were there, here, by Lord Justice Snowden. It is the case that shares are not chattels, they are shows in action. They are a bundle of rights, so what they are, their nature is dictated by the legal system under which the rights exist. As a result, the legal nature of the undertaking shares undoubtedly changed as a result of the migration to Russia. And they are therefore not the same shares because they are not the same bundle of rights. They may have equivalent economic value, but they are not the same bundle of rights because they are rights that exist by virtue of a Russian judicial system. And that, we apprehend, was in fact acknowledged by Mr. McGregor again. If we just look very briefly, supplemental bundle, tab 36. page 217, paragraph 198.3, the nature of the undertaking shares did not change until the continuance completed in July 2019. So it is quite apparent he is acknowledging that the nature of the undertaking shares did change on completion of the continuance. And that point was put to my learned friend's predecessor in the Court of Appeal last time. If you look very briefly, tab 43, page 252. If we look at the on page 252, top right hand transcript page is page 339. And if we pick up page 339 at line 17, Mr. Pillow, appearing for Mr. Deripaska, said, shares essentially I submit, he was saying that the shares continued to exist, but of course they were different in nature. They were not certificated Jersey shares. They were uncertificated Jersey shares. Of course that's right. And Lord Justice Snowden said it's actually wrong as a matter of English law, and in fact, you've no expert evidence of another law. As a matter of English law, shares are just a bundle of rights, which are enforceable against a company, and they're subject to enforcement under a particular system of law, subject to that domestic law. So by definition, a bundle of rights in a Jersey registered company subject to Jersey law is plainly different, a different bundle of rights, than a bundle of rights which refer to a Russian registered company enforceable under Russian law. A share is not a thing. A share is a shows in action. It's a bundle of rights. That's right, my lord. I accept that. My learned friend's analogy is they started with a Rolls Royce and were left with a larder. That's an analogy on a slightly different point, but in any event, and they're just picking it up again, the top left-hand transcript page on the next page, so bundle page 253, transcript page 341. Lord Justice Snowden says line 6. What Russian law actually, the least extract we have, says is that the shares in the Russian company have to have at least equivalent rights to the rights that existed in relation to the rights in the company of origin. But it does not actually say they are the same shares, or indeed that they are the same rights, because they just cannot be. And Mr. Pellet says, I'm not suggesting otherwise. And that then is dealt with in the Court of Appeal judgment, which is the next tab, so tab 44, page 284. And I think your lordships will be familiar with paragraph 97, which is where this point emerges in the judgment. And we do also emphasize footnote 9. As already indicated, there's no expert evidence on foreign law. It appears that the rights attached to the shares in an international company must correspond to the rights under foreign law legal entities charter, or be broader than those rights, although there therefore appears to be an attempt under Russian law to equate the content of the rights given to shareholders under Russian law to the rights that they have under Jersey law from the perspective of a third country. England, they are plainly not the same rights because they are not conferred under or enforceable in accordance with the same legal system. And one doesn't, with respect, need evidence of foreign law for us to invite you to accept that that is true. So just coming back then to that, having identified what the effect of the redomiciliation was, the question then is, did the underlying assets remain available? And if you are with us on the interpretation of the undertakings, the underlying assets plainly did not remain available because the shares as defined no longer existed, and enforcement against the underlying assets was thereafter impossible, and the share certificates were invalid, and therefore the RPC undertaking was frustrated. So the first element of the breach in 3 obviously is Mr. Deripaska procured something, which we say he did. The practical result of what he procured is that the underlying assets were no longer available for any form of enforcement, direct or otherwise. So as I say, if you're with us on the meaning of the underlying assets, we then do not also have to prove that Mr. Deripaska's actions resulted in any assets not being available for direct enforcement. The meaning of direct enforcement, in a sense, doesn't matter if the underlying assets aren't there at all. But in any event, for completeness, we'll just address you briefly on that. And as I say, the interpretation we've offered, as you will recall, the interpretation we've offered of the expression available for direct enforcement is that the assets subject to the undertakings would remain amenable to enforcement in the reliable jurisdictions contemplated by the undertakings themselves, England, BVI, potentially Jersey, without my clients having to resort to enforcement proceedings in Russia. And we've already made the point that by reason of the migration, the share register ends up in Russia, and in order to perfect any share sale, there would have had to be, if there was any dispute, a resolution of that in Russia, under Russian law, in relation to the share register there. So we submit both that the underlying assets were no longer available, and indeed no assets remained available for direct enforcement within the meaning of the undertakings that were given. So the next question under breach 3 is, could Mr. Deripaska have taken steps to ensure that the underlying assets remained available? Because the allegation is that he failed to take all steps as are necessary to ensure that the underlying assets remain available. Could Mr. Deripaska have taken steps? The answer is that in the judgment below at paragraph 17, as we have seen, the judge below decided at paragraph 17 that Mr. Deripaska either did or could have procured B Finance how to vote, and Milene Friend, with respect, can't go behind that. It's common ground that B Finance held over about 54%, and we've already pointed out that a special resolution was required. So if Mr. Deripaska had taken the step of directing B Finance to vote against the resolution, then the resolution could not have been passed. So in our submission, breach 3 is made out in those ways. Breach 2, working our way up the page, this requires us to start with the B Finance undertaking, which is at tab 10, paragraph, so that tab 10 and page 101. And the B Finance undertaking is that the company will not dispose of, D, 5D, is that in the event of any final judgment being made in the arbitration and Mr. Deripaska not paying, 2, 4, 5 lines down, the company will take all necessary steps to sell such quantity of the shares as is required to meet any balance of such payment which may be outstanding, and for the proceeds of sale to be used to satisfy such outstanding balance. So the undertaking by B Finance is to sell the shares, and the ancillary undertaking by Mr. Deripaska at tab 11, paragraph 4A, I shall not take any step or procure the taking of any steps which, whether directly or indirectly, in my capacity as ultimate beneficial owner, which has the effect of preventing, impeding or obstructing the fulfilment of the undertakings set out in the B Finance letter as they fall for performance. So the allegation is, again, that in procuring or permitting the B Finance vote in favour of the redomiciliation, Mr. Deripaska did take a step which had the effect of preventing, impeding or obstructing the fulfilment of the B Finance undertaking, in that the vote permitted the redomiciliation, which resulted in B Finance's inability to sell the shares because the shares didn't exist anymore.
Is there a difference between procuring, which I can accept requires some positive action, and permitting, which merely requires a failure to do anything? So when you allege that Mr. Deripaska procured and took a step in the face of the judge's non-finding of procurement as opposed to permission or not stopping it, are you able to sustain that breach? And I think the same point applies to breach 1, where you seem to have to show that Mr. Deripaska did something rather than that he didn't do anything.
Well, there are two aspects to the answer. The first is that the evidence from Mr. Deripaska was that he gave general, I think, guidance
Yes.
as to how, so that is a step.
But I think he did that, did he not, before the undertakings were given? They couldn't have been a breach.
Well, he was,
As I understand it, he was generally supportive of the Barker plan.
the
And
Barker plan didn't require redomiciliation. The Barker plan was Mr. Deripaska reducing his shareholding and abdicating board control. The redomiciliation comes in because in order to reduce his shareholding, so we are told, VTB, I think, agrees a debt for equity swap. And so
what is the evidence that Mr. Deripaska did something after giving the undertakings?
the evidence is that we relied on the witness statement of Mr. McGregor, who said Mr. Deripaska did vote the B Finance shares. That's Mr. McGregor's second witness statement. That was then followed by, I think, Ms. Berard's fourth, which said we are relying on that assertion. The assertion that Mr. Deripaska that Mr. Deripaska voted the shares was never actually retracted. Mr. Deripaska put in what we submit was an evasive witness statement, and Mr. Wisniewski, who actually cast the vote, never put in any evidence. So what we then had was an assertion by Mr. McGregor, which was never overtly retracted. We had an admission by Mr. Deripaska that the vote was in accordance with his wishes. We had no evidence from the man who actually did the vote. We had two witness statements, I think, from Mr. Makarov and Mr. Valiev, Miss Valiev, both of whom said they never had anything to do with the voting. And the third witness statement was from somebody who said, I told Mr. Wisniewski, and I'll find the relevant paragraph because this may be the last sort of brick in the structure. Mr.
Valiev.
It was Valiev. Sorry, it was Mr. Valiev travels with Mr. Wisniewski to the general meeting. He says, I told him that he should vote, and in his witness statement and in cross-examination, Mr. Deripaska says that Mr. Valiev had authority. So the answer, sorry, it's a very long answer to your question. There is no direct evidence that Mr. Deripaska personally picked up the phone and said, vote. But the evidence is, first of all, from the witness statement of his solicitor that he did vote, and the evidence from Mr. Valiev and Mr. Deripaska's own admission is that Mr. Valiev had Mr. Deripaska's authority to tell Mr. Wisniewski how to vote. Breach 2, is where we were procuring or permitting B Finance to vote in favour of the redomiciliation. involved a step which had the effect of preventing, impeding or obstructing. The judgment below dismissed this on the basis partly that the whole thing is premised on automatic cancellation, and the judge said there wasn't automatic cancellation. The other point, paragraph 70 of the judgment below, which in the interests of time I won't go to, but the other point the judge made was that he understood our case to be that the redomiciliation resulted in the shares not being capable of realising any value, and he said there was no evidence to support the suggestion that the redomiciliation reduced the value of the undertaking shares. We submit that the first reason the judge gave is wrong for the reasons we've already given. I don't need to expand on it. In relation to the second point, with respect, that is a misunderstanding. We were not making a separate and different allegation that the redomiciliation resulted in the shares diminishing in value. Value, as I've said, was never really our concern. The question was whether the shares were available of realising value capable of meeting the outstanding balance, and that revolves around the question as to whether or not the shares, capital S, continue to exist at all. So finally, breach 1, and this takes us to the B Finance Undertaking paragraph 5B, which is at page 101. The company will not dispose of the shares or otherwise deal with them. And again, we rely on a breach by Mr. Deripaska of his undertaking 4A, not to take any step or procure the taking of any steps, which has the effect of preventing, impeding or obstructing the fulfilment of the undertakings by B Finance. And the allegation simply here in relation to breach 1 is that Mr. Deripaska did take a step which had the effect of preventing, impeding or obstructing the fulfilment of B Finance's undertaking because the relevant undertaking was not to dispose of or deal with the shares, and the effect of the re-domiciliation was that the shares were disposed of in the sense that they ceased to exist. The judge dismissed that argument, partly again on the basis that it was predicated on a need to prove that the shares were cancelled, which we've already dealt with, and partly, and this is paragraphs 72 to 74 of his judgment, partly on the basis that there was in any event no disposal of or dealing with the shares. That, very shortly, our response on that point, we've already dealt with the question of cancellation. The question of dealing or disposal is simply a matter of a legal analysis. We accept, obviously, as a matter of general law, as a general proposition of law, that voting a share in and of itself does not necessarily constitute a dealing or disposal, but the proposition doesn't, that as a legal proposition, doesn't answer our point on the facts of this case, because we say on the facts of this case, the vote at the general meeting, which permitted the redomiciliation to go ahead, indirectly impeded, obstructed, or obstructed the fulfilment of B Finance's ability to perform its undertaking, which was not to deal or dispose of, because the consequence of the resolution was the extinction of the undertaking shares. So we're not saying that a vote at a shareholder meeting is in itself a disposal. We are saying that it is the consequence of the resolution that is passed that constitutes the dealing or disposal here. So we submit that breach 1 is also established. I just wanted to spend then a few minutes identifying some of the errors in the judgment below which led the judge to the conclusion that he did before moving on to the remaining parts of the appeal. So, in relation to the judge's errors, we submit first of all that the result of him not analysing the meaning of the undertakings or identifying the subject matter of the undertakings is that he wrongly held that the change from certificated shares with share certificates held in London to dematerialised shares with a share register held in Russia had, in his words, had no impact on the underlying securities and was immaterial for the purposes of the application. That is paragraph 57 of his judgment, which is tab 6, page 71. And in our submission, that demonstrates to say that the migration resulting in the extinction of the certificated shares in a Jersey registered company had no impact on the underlying asset, on the underlying securities, and was immaterial. In our submission, betrays a fundamental failure to understand either the meaning or the objective of the undertakings. If that's right, the RPC undertaking never had the slightest value. He also, for the same reason, because he didn't analyse the purpose, the effect of the undertakings or the subject matter of the undertakings, he also wrongly accepted an argument from my learned friend that because the shareholders' rights in EN plus Russia were essentially the same as their former rights in EN plus Jersey, therefore the undertaking shares were not cancelled. That's paragraphs 53 and 55. That is a non sequitur. From the shareholders' point of view, their rights as a shareholder under EN plus Russia may well have been broadly equivalent or indeed identical in economic terms to their rights under EN plus Jersey. But the point of the undertaking shares is that they were shares in a Jersey registered company, and the question of whether the subject matter of the undertakings was cancelled is answered by reference to that, not by reference to the shareholder rights of shareholders, because my clients never were shareholders. And another, just a final and incidental point, the judge's failure to analyse, to scrutinise carefully the undertakings themselves led him to misconstrue in particular the effect of the RPC undertaking. I won't take you to it, but in paragraph 58 of his judgment, he says that it was never intended that RPC would sell the shares. In our submission, and he goes on to say that RPC was simply provided with the share certificates as a rather modest form of security. And in our submission, that again fundamentally fails to understand the significance of the package of undertakings. And as it happens, misreads the actual content of the RPC undertaking, which was both a negative undertaking not to dispose of or otherwise deal with the shares in any way, and then a positive undertaking, if non-payment arose, to take appropriate steps to facilitate the sale of such number of shares as are required to satisfy any order of the court. So that merely provides some illustration of the lack of, in our submission, proper scrutiny of the content of the undertakings. So we submit that there has been established the three breaches on the basis of the material that was available to the judge. And the next question is whether it is open to us to allege that the breach or breaches were deliberate. And you'll be aware from my learned friend's respondent's notice, additional ground 8, that his position essentially is that he says, well, I'll let him develop it and I'll answer it if he does. But just so the court understands and my learned friend understands our position, I'll merely outline very briefly what we understand his point is and what our headline response to it is. As we understand it, the argument from my learned friend is that we did not put to Mr. Deripaska in cross-examination that he knew he was acting in breach of the undertakings, and so my learned friend says we are now precluded from suggesting that any breach was deliberate. In very short order, our response is this, and incidentally my learned friend relies on the case of Griffiths and Tewey travel company, which we don't need to go to now, which is in the authorities bundle, authorities bundle tab 13.
When you're using the phrase deliberate breach, I mean, it could mean one of two things. It could mean that Mr. Deripaska deliberately did something, deliberately failed to do something, which as a matter of analysis is a breach of the undertaking.
Yes.
Or it could mean that he deliberately broke the undertaking. I think you're using it in the latter sense.
Sorry, yes, I am. Yeah, so in order to establish a breach, as I understand, and I think this is common ground, one has to establish that the accused, the respondent, knew the terms of the undertaking, acted in a manner which involved a breach of the undertaking, and knew of the facts which made his conduct a breach. But one does not, in order to prove a breach, one does not have to prove that he knew that those acts involved a breach.
So when you're talking about deliberate breach, you mean he knew it was a breach?
Contumacious, yes, or however one wants to put it. So yes, that's the way I'm using deliberate. So the argument from a learned friend is we didn't put this in cross-examination, therefore it's not open to us to say that Mr. Deripaska knew that the vote involved a breach. Just to give the outline of our response, we say, first of all, that the applicable legal test for answering this debate is fairness of the trial process. In particular, the question is, are my clients inviting the court to make a finding on a point that Mr. Deripaska did not have a fair opportunity to answer? That's the legal principle you get from the Griffiths and Tewey case. Applying that test, we will submit that there is nothing remotely unfair about asking the court to make a finding that any breach by Mr. Deripaska was a knowing breach, deliberate breach, one wants to put it, contumacious breach. And there are essentially three elements to that response. The first is that our clients made it clear long before we got anywhere near trial. My clients made it clear that the case Mr. Deripaska had to meet was of deliberate breach, because that is what the committal application says.
It's paragraph 22A.
Yeah.
Which was pleaded by way of amendment in February 22.
Yes.
So on that hypothesis, over a year before the hearing.
Yeah. And the point was made, if it needed to be, not only by way of, so to speak, the pleading of paragraph 22A, but also in Miss Berard's 8th witness statement. She made at least on 3 occasions, paragraphs 69, 72 and 105, she makes it clear that the allegation is that there was a deliberate knowing breach. Maybe that's the better word to put in, a knowing breach. As a result, our second point is that Mr. Deripaska had the opportunity to answer the allegation and took it. He knew perfectly well what the case against him was, and Mr. McGregor's affidavit makes that clear. If we just look at one sub-paragraph in Mr. McGregor's affidavit, which is paragraph, it's supplemental bundle, tab 36, page 216. And this, actually, I might just look at 194 and 195 because it frames the entire basis of the committal application. 194, Mr. McGregor says, the key event that underpins the committal application is not in dispute. B Finance, the company of which Mr. Deripaska is the ultimate beneficial owner via a corporate and trust structure, voted in favour of the continuance of the general meeting of shareholders on the 20th of December 2018. Further, it is not in dispute that B Finance voted in favour of the continuance in accordance with Mr. Deripaska's wishes. He supported the Barker plan and the continuance as the processes by which the US sanctions could be lifted from EN Plus and the contemporaries and the company saved, and had indicated by early to mid-May 2018 that his employees' advisors should support their implementation insofar as possible. He has never denied as much. Instead, two questions arise. Namely, do the facts described above and in the other evidence served by and on behalf of Mr. Deripaska demonstrate a contempt of court? Two, if so, was that contempt clear, deliberate, flagrant, and an affront to the court, as variously alleged in paragraphs 569 and 116 of Berard 8. So it is perfectly clear Mr. Deripaska knew that the case he had to meet was of a deliberate, clear, flagrant breach of the undertaking. And as I say, Mr. Deripaska took the opportunity of answering that by putting in his fifth affidavit, of which we always had extracts, and we now have the full thing at tab 53 in the supplemental bundle. I won't go through it, but it is perfectly clear that he starts with an apology, which we understand to be a mea culpa, and then he goes through to explain why he says it wasn't a knowing breach, because he says it didn't occur to him and he wasn't advised as much. So we made the allegation long before trial. Secondly, Mr. Deripaska had an opportunity to and did answer it. And thirdly, we did put to Mr. Deripaska in cross-examination the factual points from which we would invite the court to infer that the breach was a knowing breach. I readily admit I did not use the old phrase, I put it to you, Mr. Deripaska, that you knew this was a breach. But the requirements of fairness are not dependent upon matters of mere form. If I had invited the court to draw an inference that the breach was a knowing breach by reference to an evidential point which had not been put to Mr. Deripaska, that might have been unfair. But we did put to Mr. Deripaska in cross-examination the whole history of his animus towards my client, the fact that he had been advised as to the meaning of the undertakings, the fact that he was fully cognizant of the effect of the redomiciliation as described by his solicitors, the significance, among other things, of the timing of that RPC letter in May, immediately after the Jersey Financial Services Commission had given its approval, various other matters. I won't go through them all now, unless my learned friend does pursue this point. But in our submission, it was quite apparent that we put in cross-examination to Mr. Deripaska the evidential points, as I say, on the basis of which we would then invite the court to infer that the breach was a knowing breach. And so on that basis, we submit that there is no ground for this court, there is certainly no ground for the court below to say that it wasn't open to us to invite the to invite the courts to make a ruling on contumacy. As it happens, the judge said it. I'm sorry.
As it happens, the judge didn't deal with it because
No.
he didn't think he needed
No,
to.
he said it would be inappropriate to make any findings. Since, as I say, the question whether the breach was a knowing breach is relevant not to establishing a breach, but to the gravity of any breach, and hence to the appropriate sanction. If this court is with us on the meaning of the undertakings and the assertion that there has been a breach or breaches, in our submission, the appropriate thing, in the absence of any findings about what Mr. Deripaska knew or understood by, in the absence of any findings on those matters by the trial judge, regrettably, the only appropriate way forward will be for that question, the question of contumacy, to be remitted for further consideration in the court below. Because there isn't the material in this court, in front of this court, to make any ruling on that.
On the basis that you will have a further crack at cross-examining Mr. Deripaska if he chooses to give evidence.
Well, one will no doubt have to have a discussion about whether or not any further cross-examination is even necessary, or whether it's appropriate to reopen, because the trial ended, and we then made our submissions on the evidence that had been adduced. I wasn't assuming that we would make an application to cross-examine him on a point that, in our submission, we already sufficiently cross-examined him.
Okay.
But it would then leave a trial judge in the unhappy position of not having heard the cross-examination, but having to make, or unless the same judge hears it.
Are you inviting any direction from us about whether it should or shouldn't be the same judge if this point arises?
I am not on my feet now. Can I take instructions and think about that
Because
overnight?
on one view, the judge has not said he's not in a position to deal with it. He
No.
just said he didn't need to. So
Yeah. Yeah.
it may be that he could simply go back to him without any further hearing being needed.
Yep, that's
Obviously, if it
conceivable.
goes back to a different judge, then
It'd have to
it's
be
a very
further-
different situation.
That's what I had in mind.
Can I think about whether asking for directions would be appropriate overnight? That brings us to the shortest point, which is just the question of costs. And you'll recall that there was a separate costs judgment in the core bundle at tab 7, page 76. And permission to appeal in relation to that was granted insofar as the judge below awarded costs on the indemnity basis in relation to costs of an occasion by responding to the 8th affidavit of Miss Berard. So far as that is concerned, I don't think the applicable legal tests are in doubt. The judge below, citing Excelsior, paragraphs I think 31 and 39, considered that the appropriate test was whether or not the conduct of my clients or the circumstances of the case take it outside the norm, and that's the costs judgment at paragraph 4, which is on page 77. I think it's common ground that that was the correct test. The test on appeal is whether the trial judge either ignored significant relevant factors or took into account materially irrelevant factors, or reached a conclusion which is wrong in the appellate sense. And in our submission, and I can deal with this quite briefly, but in our submission, there are a number of significantly material matters which were either not taken into account or were taken into account when they should not have been. And if I can just move through those very shortly. So,
Just before you do you have, I appreciate its costs on the other side, but it's quite a limited order.
yes.
I know people get quite excited about indemnity costs, but do you have any idea of what this point is actually worth?
Well, that was going to be
Standard
one
indemnity.
of our concerns, and I will take instructions as whether anything has gone forward, but one of the peculiarities of the judgment on costs is that in paragraph 15, the judge says that it would not be proportionate to award indemnity costs in relation to the whole of the costs of meeting the claim. But he then says that the costs of responding to Miss Berard's 8th witness statement should be on the indemnity basis. I have to admit, it's unclear to me what that actually means, because Miss Berard's 8th witness statement was the evidence in support of the committal application. I mean, on one view, I don't know whether any progress has been made on detailed assessment. On one view, all the costs of meeting the committal application could be regarded as the costs of responding to Miss Berard's 8th witness statement. So I don't know the answer to your question, and I don't actually know how to answer your Roger's question. That was actually going to be a sort of bit of a tail end point on either uncertainty or potentially inconsistency. But in any event, the points we just wanted to make very briefly are, first of all, that the fact that this court, the Court of Appeal, on the last occasion we were here, found that the allegation of a serious breach was reasonably arguable. And that was, as we saw earlier, discounted. It was something the judge regarded should be left out of account when it came to his interpretation of the undertakings.
Yeah.
But he also regarded it as something that was not relevant for the purposes of his costs judgment. If we just go back to paragraph 10, page 79, which I read to you a little earlier, where he says that in his judgment, the decision of the Court of Appeal has to be set in context. It didn't attempt to evaluate whether the breach had been demonstrated, much less did the Court of Appeal attempt to evaluate to the criminal standards. Therefore, it seems to me that the view that the Court of Appeal took in the context of a narrowly focused appeal on a procedural aspect of the claim is not an outcome which detracts necessarily from a point that on in-depth analysis, the application as framed was evidentially flawed. That, in our submission, is just wrong. The court...
Maybe it is, but it leads him to reject the third of Mr. Grant's points as a basis for directing the cost be assessed on the indemnity basis. So he's saying, well, that may be a point, but it doesn't justify costs on the indemnity basis.
Well, with respect, it's quite difficult to know what he is actually saying in paragraph 10, because it's a paragraph of two halves. He starts by dealing with the Court of Appeal, the relevance of the Court of Appeal judgment. And then at the top of page 80, he says, I agree that merely because a claim fails does not justify ordering the assessment of costs on the indemnity basis, however fundamental the basis of the failure, unless it can be said to be unarguable. I emphasised throughout that the substantive judgment I was addressing, the allegations actually made applying the criminal standard, drew attention to both the narrow way in which the application had been formulated and the absence of evidence in critical areas. Looked at in that way, this is a committal application that failed on a factual analysis of the allegations made against the evidence adduced in relation to them. Yeah. In those circumstances, the application was not outside the norm.
So he's dealt with that point. He said, well, that's not outside the norm.
But
what leads him to his conclusion is the way in which Miss Berard's affidavit was expressed.
Yes.
And basically he's saying it was designed to ramp up the heat and not cast light on that's his real reason.
Paragraph 7.
I agree that is his reason, but what he isn't doing in paragraph 10 is taking on board the relevance of the fact that the Court of Appeal had made a ruling, had expressed a view as the arguability, not on a procedural aspect of the claim, but on the substance of the claim.
For sure.
So he isn't taking into account a relevant factor in paragraph 10. He isn't then also taking into account the relevant factor that Mr. Justice Tier said a similar thing, albeit very briefly, in July 2019. Paragraph 13 then takes into account simply the fact that the allegation was of a deliberate breach or contumacious breach. Now, that doesn't take a matter outside the norm. There was evidential material to make that allegation. We made the submission on the basis of the evidence by way of inference, and saying that simply because a party alleges that a breach is contumacious, that takes it outside the norm. But in paragraph 13, he does, with respect, seem to be taking that into consideration. But then, as your lordships rightly say, in paragraph 14, he talks about the Berard 8 and the skeleton that was prepared for the hearing in front of Mr. Justice Andrew Baker, and he says they were expressed in respects that was highly inappropriate. But then, in fact, having mentioned both the skeleton and the witness statement in paragraphs 16 and 17, he then finesses it somewhat and founds his decision on Miss Berard rather than the skeleton. And we would just say 2 or 3 things about that. The first is that by fixing costs in the way he did, by reference to Miss Berard, the judge did not take into account the at least partial exculpation of Miss Berard in the Court of Appeal in the earlier judgment, at paragraph 140 of the Court of Appeal's judgment. It was not necessary for the court on that occasion to do an entire sort of give it an entire bill of health, but they do mention, they make a point of mentioning at page, so it's supplemental bundle, tab 44, page 294, paragraph 140. And I agree, it's expressed in somewhat modulated terms, but it is a relevant factor, and it isn't mentioned. So in the 245th line down, on points of detail, Lady Justice Carr says, I would note that there are also areas where the criticisms levelled at the appellants and Miss Berard may not have been fair. And then she lists various points about the previous findings of dishonesty made against Mr. Deripaska. On at least one reasonable view, the material was relevant to credibility and, for example, sanction. There is an allegation of inconsistency, which the court also dealt with. So
the difficulty here is, I think, one you've really already focused on. I mean, I think my interpretation of what the judge was concerned about is he was concerned about the use of
some adjectives,
certain adjectives and adverbs,
yeah,
which he didn't like,
yeah,
and that's what he was, as it were, punishing your
yeah,
client for it by ordering indemnity costs.
Yeah.
But the difficulty is he hasn't begun to give any sort of guidance as to how that would work out in practice in terms of the ultimate costs order.
No.
If, on the other hand, the effect of what he's done is to say, well, in that case, the whole of the costs of Berard, of responding to Berard 8 should be indemnity costs, then it seems to me he's gone way beyond what would be appropriate in the circumstances.
Yeah.
Because that would mean the costs of all the responding
yes,
to the whole application, and that doesn't seem to be what he intended.
well,
And that's really your short point, isn't it?
well, that certainly is one of them, and I gratefully adopt that, and I won't need to expand on it. Could I just add a couple of other very short points? When it came to presenting the evidence in support of the committal application, first of all, as a matter of fairness, Mr. Deripaska needed to know what case was being made against him, namely a contumacious breach, a knowing, deliberate breach by somebody who was an acrimonious litigant motivated by animus against my client. So putting him in, as a matter of fairness, in the picture of the case he had to answer, as a matter of form, the old CPR Rule 8110 required, and that's quoted in the Court of Appeal's judgment, paragraph 81, it applies to this application, although it's no longer in force in those terms. But old CPR 8110 required the application for contempt to be supported by affidavits containing all the evidence relied on. So that would include evidence going to sanction. Yeah. Clearly, putting in evidence on, for example, past dishonesty, which goes in our submission to both the context of interpreting what the undertakings were intended to achieve and also going to Mr. Deripaska's credibility was a necessary and relevant thing to do. And the third
Well,
point,
once you accept, if the Court of Appeal did accept that, and anyway you submit, that the previous history of misbehaviour by Mr. Deripaska is potentially relevant, at least to sanction, it's a bit hard to see what extra costs would have been incurred by
yes,
having to respond to language which might be slightly over the top.
that is ultimately the final submission. The only prequel to that is in our submission, the language was not over the top. The whole predicate for this order is misplaced. The particular phrases that have been identified in my learned friend's skeleton, paragraph 74, Ms. Berard uses the expression flagrant breach. Flagrant breach, my learned friend said in our, we had said in our skeleton that it's frequently used in judgments to describe a breach, and my learned friend said, well, you haven't cited any. So simply from the last month, we've identified two. I don't ask you to go to them, but both lim and ong, which is in the authority.
Justice Bacon, yep.
Authorities Bundle, tab 16, uses the expression flagrant breach 5 times in the course of the judgment at paragraphs 8, 34, 53, 62 and 73.
Well, in intellectual property cases, you can award extra damages for flagrant breach. Statute says so.
So just as a matter of language, it is not to be frowned upon. It is in a sense a term of art. Fundamentally dishonest case is the next complaint. Well, so far as we are concerned, that is an entirely fair, one might say a restrained description of a litigant who bribed somebody to bring a false claim and himself.
Another phrase that appears in the CPR in personal injury cases where you can disallow, make somebody pay the costs if their case has been fundamentally dishonest.
And in any event, Mr. Justice Tier found as much, didn't he?
Indeed he did. So, yes, exactly. So paragraphs, I've given you the reference 284, 285 of Mr. Justice Tier found that Mr. Deripaska gave knowingly false evidence. Ms. Danilina gave knowingly false evidence that Mr. Deripaska paid her to bring the claim and to give the evidence. As it happens, although you may not have focused on this, it was found by the arbitral tribunal. The arbitral award isn't in the papers, but the arbitral tribunal found that Mr. Deripaska had suborned other witnesses beyond just Miss Danilina. That's Miss Berard 8, para 19. And at trial, Mr. Justice Tier found that 2 other witnesses called by Mr. Deripaska gave false evidence. That's paragraphs 35 and 39 of his judgment. So to describe the case run by Mr. Deripaska as fundamentally dishonest in our submission is nothing more than the truth. Egregious breach is another expression about which complaint is made. In our submission, that adds or detracts nothing to flagrant breach. Systematic dishonesty is another expression that's lit upon. But again, that doesn't change anything. It was another way of describing the fundamentally dishonest case with, as far as one can tell, systematic suborning. The final point of complaint is made about Ms. Berard describing as an entirely inappropriate application, the application to set aside the undertakings. There's nothing particularly inflammatory about that language, and in any event, we would submit that it was an entirely fair description of an application to discharge undertakings instead of applying to the court to provide replacement security as a condition for being released from the undertakings.
It sounds as if, like Lord Clive, you are surprised at your own moderation.
Indeed so. And your lordships have already stolen my punchline, which is that there is absolutely nothing to suggest that any of this language increased the costs of responding to the application. So in our submission, it is one of those rare cases where a discretionary ruling on costs was wrong in the appellate sense. Can I just check if there are any other points to open? But I'm more or less where I thought I would be at this point. I'm grateful. Unless there are any questions, that's what we wanted to say in opening.
Thank you very much indeed.
I'm grateful.
Yes, Mr. Grant.
It is good. I wanted to start with the first question, which we say logically presents itself in respect to this appeal, which is what is its actual purpose? It's a legitimate question to ask where a very large amount of court time has now been spent on this application since it was issued in November 2019. Multiple applications to the High Court judge, 2 trials, 1 visit to the Court of Appeal and another visit to the Court of Appeal now. A vast amount of legal cost has been expended on both sides in respect of this appeal. And as I say, it is now 4.5 years on from when it was first issued. It's a legitimate question to pose, my lords, also in light of the fact that appeals by claimants against dismissals of contempt applications are, as was described by Lord Justice Lloyd in the BTA and Eroshenko cases in your lordship's bundle, I don't take you to it, as, quotes, very rare, end quotes. This is apparently one of those very rare appeals.
Yeah.
Now, what I'd like to do to begin with, my lords, is offer some introductory observations as regards that question, and then offer some introductory conclusions as to what should follow from the answers to that question. Now, the court, not quite apart from the matters that I've already identified to the court, length of time, expenditure, amount of court time spent, etc. There are, we say, a large number of factors in this case which take it outside the normal run of commercial contempt cases, which this court from time to time has to deal with. Not only unusual, but we say in some senses unprecedented. And I want to set out some headline submissions on what we say are the unusual and indeed in some senses unprecedented aspects of this case. And then I'm going to unpack a few of them thereafter.
Well, you've outlined quite a lot of the considerations that you rely on in your skeleton argument.
Yes.
What I couldn't readily see was where it leads this court and what order it means this court should make, whether it means we shouldn't deal with the merits of the appeal, whether we should, what we should do with it.
Well, my lord, the avowed intention of the appellants is for your lordships to allow the appeal and then remit this case back to the High Court, for that court to deal with the question of contumacy and sanction. So the avowed intention of the appellants is for this case not to finish here, but for this to be another staging post towards a further hearing, final hearing, before the High Court in due course.
Yeah. Now, suppose we were with Mr. Crowe on the construction of the undertaking, and suppose we decided that yes, there was a breach. Then what? You say, well, enough is enough. That just make a declaration and leave it at that. Is that the sort of course you would invite us to take? I'm not quite sure where these points are going.
My lord, we say enough is enough. Absolutely, we say that, and I would like to develop those points. But we also say, and this is an aspect of the submissions I was about to advance, that there is no proper basis on which any court, whether Judge Pelling or any other judge, could make a finding of contumacy. And that engages one of the submissions my learned friend made.
That's a little bit further down the line, isn't it? I mean, really, you have to grapple with the issue of whether your client was in breach of the undertakings or not. If he wasn't in breach of the undertakings, for all the reasons you give, then none of this matters. The appeal is simply dismissed. But if Mr. Crowe is right, then on his case, as he's presented it to us today, Mr. Deripaska was in contempt, and the sort of history. We know the history. We know how much your client and Mr. Chanukin apparently loathe each other, and we know that this court is being used in a sense for them to fight out their long-running battle against each other. But that's neither here nor there. If he was in breach of the undertakings, then we have to deal with, and the appeal will have to be allowed. What we will do with it then, I don't know.
Well,
so that's really what. Speaking for myself, I'm not sure I'm helped by having spelt out the sort of torturous history and who scored which point off who.
But
what we really want to know is what your case is on.
Can I say, my lord,
breach of undertakings.
I was not proposing to resurrect the supposed battle between my client and my learned friend's client. And when my learned friend, when dealing preemptively with some of the submissions I made in writing, he said, well, the whole question of abuse has been answered by the last Court of Appeal. A judgment is handed down, the application to strike out and the decision of Mr. Justice Andrew Baker is set aside. I'm certainly not going to be re-arguing those points at all. I'm not going to be making or touching upon any question of subjective motive or subjective malice or anything like that. Far from it. What I was going to say to this court was that in Lady Justice Carr's own judgment in the Court of Appeal last time, she endorsed the proposition that applications for contempt can become disproportionate, and the court needs to be on its guard against applications which have become disproportionate. Now, I quite understand that in 2021, when the Court of Appeal entertained the appeal advanced by Mr. Crowe on that occasion, the court was not in a position to say this application has become disproportionate. And one of the key reasons why it wasn't in a position to say this case or this application has become disproportionate, which is a separate concept, I should say, from subjective malice, which was the foundation on which Mr. Justice Andrew Baker struck out the claim. The reason for that, my lords, was because at that stage it was being, on the face of it, alleged by Mr. Chanukin that my client had not only committed a breach of the undertakings, but had done so with a contumacious state of mind. And of course, that question could not be decided at that stage because a trial had not yet taken place and Mr. Deripaska had not yet given evidence. But we're now in a very different position. 3 years or so have gone by since the last outing to the Court of Appeal. We've had a trial, and we've had a trial in which I say Mr. Deripaska was not cross-examined in the way that were contumacy to be advanced now, he would have had to be. And I disagree with my learned friend, and I would like to explain why, and have the opportunity to explain why I disagree with Mr. Crowe's submissions on contumacy. The position we are in now, Mr. Deripaska, having been cross-examined for a number of hours before Judge Pelling, is that the bulk of his evidence was unchallenged, as I will endeavour to show the court. And what that means in practice is A, that the reasons why Mr. Deripaska was in agreement with the Barker plan and why he was in agreement with, putting aside the question of procuration, in agreement with the fact of the continuance in general terms, and he set it all out in his evidence. That was not challenged. And those aspects of his evidence reveal a very different picture to the one that the Court of Appeal 3 years ago might have expected to be revealed. The second aspect of this is that not only was Mr. Deripaska not cross-examined on his motivations and his thinking back in 2018 when the relevant events occurred, he gave specific evidence in his affidavit. He addressed in terms the question of whether or not he had understood and thought at the time that the continuance, the fact of the continuance, would constitute a breach of the undertakings he'd given. And he was emphatic but careful in his evidence to say, it never crossed my mind that the continuance, which I had in broad terms given agreement to, we have a separate point on procuration, it never crossed my mind that that continuance would in any way involve my undertakings being breached. In fact, as far as I was concerned, that continuance, which was a precondition to the Barker plan actually happening, as I will again endeavour to show this court, was to the immense benefit not only of N+, a very substantial company, but to its thousands of employees, the millions of people who gain their energy from N+, and he goes into this, and to the immense benefit of the creditors and stakeholders and shareholders of N+, brackets including Mr. Chanukin, because absent the continuance, there would have been no Barker plan. Had there been no Barker plan, there would have been no desanctioning. And had there been no desanctioning, the evidence which was unchallenged, not just from Mr. Deripaska, but from 3 Russian witnesses as well, who weren't even called because they didn't require to be cross-examined by the claimants, was that absent the Barker plan succeeding, and absent therefore N+ being taken off the SDN list operated by OFAC, United States Sanctions Authority, then the effect would have been that N+ would have either, 2 things would have happened. One of 2 things would have happened. One, N+ would have slid into insolvency. This is spoken to by 4 witnesses called by my client. Or 2, it would have been nationalised by the Russian state. Now, what's the consequence of that? The consequence of that would have been, for Mr. Chanukin, is that he would have had the benefit, or the supposed benefit, of undertakings in respect of shares in N+, which were worthless. So the continuance, in his evidence, said Mr. Deripaska, saved N+, and also had the effect of saving Mr. Chanukin's the undertakings given for the benefit of Mr. Chanukin. None of this was contentious. None of it was challenged. Now, none of that was, of course, a material that the Court of Appeal back in 2021 knew about, quite understandably. They had no reason to interrogate those questions. Everything was to play for. There had not been a full trial. There has now been a full trial, and these matters are now fixed because they weren't challenged. So now we have a situation where Mr. Chanukin comes to this court a second time after 4.5 years of extremely expensive litigation and says, I want from this court, or I request from this court, findings of breach, and then, but not just findings of breach, but a further trip back before the High Court judge, whether Judge Pelling or some other judge, so that I can then invite that judge to make findings of contumacy. Now, I say, and I wish to develop these submissions if the court will allow me to do so, that there is literally no basis or possibility in accordance with the English law for any judge at first instance to make a finding of contumacy in circumstances where Mr. Deripaska was not challenged on any of the evidence he gave as to his failure to appreciate the possibility that what was happening could constitute a breach of the undertaking. And it's simply not right for my learned friend, as he does in the submissions he gave this afternoon, to say, well, the test is one of fairness, and Mr. Deripaska knew the case he had to meet, and I wasn't required to challenge him on his evidence about that. If one looks at Toohey and Griffiths, which does no more than, with the greatest respect to the Supreme Court, gather together a line of authority that goes back to Brown and Dunn in the 19th century. And it's a line of authority well known to this court, of course, but it's been given, if I can put it this way respectfully, the imprimatur of a very recently constituted Supreme Court. And that, the law as stated in Griffiths and Toohey is quite clear Now, if I'm right in that, my lords, then I'm entitled, I respectfully suggest to this court, to say to it that in circumstances where large swathes of the evidence given below was unchallenged, which put the continuance in the commercial and human and social context in which it took place, where Mr. Deripaska's state of mind was not challenged as to whether he was contumacious or not, and a variety of other factors which I would like to develop to this court, which are nonetheless relevant to other matters, then it would be wrong for this court to remit the matter back for a yet further hearing. Because I say these proceedings have now become oppressive to Mr. Deripaska and disproportionate.
Are you saying that we shouldn't decide the question, for instance, of interpretation of the undertakings, or whether the breaches alleged were made out?
Well, my lord, my primary position is that given the matters I'm proposing to lay out before the court, no, because to do so would simply to perpetrate or perpetuate, I should say, the oppression that this case now constitutes.
Well,
now, not then.
I can see that that might have been a reason why Lord Justice Phillips could have refused permission to appeal,
Yes, I understand.
but he didn't.
No, he didn't. He was invited to refuse permission, of course. We put in submissions, but we made our submissions, and we are here. And of course, I attend because because we are here.
The appeal is proceeding on the basis that the points are all fully arguable, and therefore, as I said a moment ago, Mr. Grant, you have to grapple with the issue as to whether your client was in breach of the undertaking.
And I propose to do. I'm not. I should say that my submissions are not intended to somehow hide from the underlying issue, because I've got a lot of submissions to make upon them.
Yeah.
But in answer to my Lord Justice Lewison's question, my primary point is that I'm not suggesting you should simply stop the hearing now. Of course, you have to hear the totality of my submissions and hear Mr. Crow's submissions in reply. I quite understand that. I hope I'm realistic in that regard.
No.
But my primary submission is that at the end of the day, this court should not lend itself to the obviously the court itself is not doing it, but the perpetration or the perpetuation of a continuing proceeding which has become disproportionate and oppressive to my client. It may be that the court takes the view it needs to decide the questions of whether Judge Pelling was right or wrong. I'd say he was absolutely right, and I've got a number of submissions, as you would expect, to advance in respect of that. But my secondary submission to say that even if the court grapples with the issues that are technically on its plate and which are before it, but it still has another question before it, which has been placed firmly and squarely before it by the appellants at paragraph 59, the last paragraph of their skeleton argument, where what they suggest and invite your lordships to do is to allow the appeal and then remit this case back to the High Court. They don't say whether to Judge Pelling or some other judge to decide the question of contumacy and sanction.
Yeah.
And I am entitled to say, with respect, I'm entitled to submit that there is no possibility that a properly self-directed judge at first instance could make such a finding. Now, what that means in practice is that we have a case of technical breach, at most. Even if my friend's right, at most it is a case of technical breach. And your lordship say, well, what does technical breach mean? Just explain to me what that means. That is a term of art, it's a term which has become a term of art via the influential decision of Mr. Justice Briggs, as he then was, in Sectorguard, where the learned judge there differentiates between technical breach and serious breach. And it's a distinction which the Court of Appeal in this case, 2.5 years ago, 3 years ago, when it handed down judgment, adopted for the purposes of distinguishing between breaches which are properly matters to be brought before a court, i.e. serious breaches, and breaches which are not properly matters to be brought before a court, i.e. technical breaches. And that has literally nothing to do with questions of subjective motive, which I should be absolutely clear about, seeking to re-argue before your lordships. None of my submissions involve any window being cast or put into Mr. Chanukin's mind. What Mr. Justice Briggs said in Sector Guard was that when dealing with a question, an application to strike out a claim for abuse of process, an application for abuse of process, was that it is not a proper use of the contempt jurisdiction to bring before the court technical contempts. And he distinguished between technical and serious contempts. And he also explained that the serious contempt for these purposes is a contempt which will attract a penal sanction. Now, we know from a whole other chain of authority, which stops with Lord Justice Nugent's decision in Keir and Watson, but Lord Justice Nugent was founding himself on a whole host of earlier authorities, that it will be very rare for any court to commit a person for a contempt that was not contumacious. When I say commit, I mean using that in the technical sense of sentence somebody to prison. That's an order of committal. Now, if it's right that this can never be anything other than a technical contempt, even if my learned friend is right on his submissions, then this falls into the first category of cases identified by Mr. Justice Briggs and adopted by the Court of Appeal in this case 2.5 years ago, and therefore it has become oppressive. My lords, can I, and therefore just to go back to Lord Justice Lewison's question, the secondary submission I make is that even if the court does want to at least provide the answer, so to speak, raised by the appeal, then it should not in any circumstances entertain the notion of a yet further trial of some sort or other, what it might be I can't imagine, before Judge Pelling or some other judge. A, because it would simply mean this case travelling into its 6th year of life, and B, because no properly self-directed judge could make a penal finding, and there could be no point, therefore, in remitting the matter back. My lords, I would like, if I may, conscious that your lordships know my point, to develop these points a little. And also I'd like to develop them because my learned friend, I'm criticising him for 1 second, but it would not have gone unnoticed that my learned friend was not backward in identifying findings by previous judges adverse to my client and identifying passages from United States sanctions authorities making various allegations against him. And I would like, if I may, to try to place this case into perhaps a fairer context than my learned friend. I quite understand my learned friend has a job to do, and he has instructions to fulfil. I quite understand. There's no criticism of him. My lords, let me very briefly just explain what I say are material factors for your lordships to take into account. The first is that the claimants were paid out in respect of the matters for which the undertakings were given to protect more than 4 years ago. Every penny, every dollar, every pound, every cent was paid to Mr. Chanukin in September 2019. The award was fulfilled, the costs were paid. My learned friend is obviously conscious of that as a relevant consideration, and therefore he made a submission about that. And he said, well, we also suffered a lot of loss and pecuniary loss, my clients having to, with all the shenanigans that occurred from June 2019 onwards. And there were hearings before Mr. Justice Tier, and they went before Mr. Justice Bryan, and there were a number of hearings before a number of judges, and there were hearings before the Jersey court as well, as my learned friend identified. And he said, well, we had to pay out a lot of money on that. Now, we know, I'm not quite sure what the point of that submission was, with the greatest respect, for this reason, that this contempt application can never put that right, because Judge because Mr. Justice Andrew Baker decided that the contractual damages claim that this case originally involved was unarguable, and he dismissed it. And my Lord Justice Mayles refused permission in respect of that. So any attempt to get pecuniary recompense out of this contempt application is obviously now, has been stopped in its tracks three years ago. And of course, it's well known that contempt applications should not be used for the purpose of extracting money from the alleged contemnor. So, and in any event, all those matters that came before the judges of the commercial court from July 2019 through to September 2019 were all the subject of, no doubt, costs orders, which were made in the way that the learned judges at the time thought were appropriate. So the fact that other pecuniary losses were sustained as a result of the litigation and the events of the second half of 2019 is neither here nor there. The underlying mischief, so to speak, against which these undertakings were proffered, i.e. the fact that there was an award which was at the time unpaid and was being challenged via the Section 67 and Section 68 proceedings, that has gone. And as a result, as the court may have picked up or may not have picked up, the undertakings themselves were discharged by consent via an order of the 4th of October 2019. So they've been
before
set
this application was made.
before this application was made, 6 weeks before. Exactly right, exactly right. That's the first contextual point that I wanted to just identify to the court.
Yeah.
The second, and I'm not going to say anything more about that. The second one, which I will come back to in a little while, if I may, is that in fact the acts complained of, whether they are technically contempts or not, and I say they are not, of course, and I'm going to come back to that. The acts complained of, in fact, benefited Mr. Chanukin, and benefited Mr. Chanukin in a way which is simply, although no doubt my learned friend would say it's not, in reality is common ground by reference to the unchallenged evidence. And I wish to return to that because it's a very peculiar aspect of this case. The third aspect of this case, which again is possibly unprecedented, is that the events giving rise to the alleged contempt took place in as public an arena as it's possible to imagine. And I will just spend a little time on this. Every step of the way towards the continuance was the subject of press releases by N+ itself and a consistent number of media reports. And indeed, it goes further than that. Not only was every step of the way the subject of publicisation to the entire world, but Mr. Chanukin himself and his legal advisors knew about it at the time, knew about it at every step of the way, and did nothing. Did nothing until they issued this application, having received their money, having discharged the undertakings on the 14th of November 2019. The fourth point, which I've addressed your lordships on already parenthetically in answer to questions put to me from the bench, is that this is, without any doubt at all, as I will endeavour to show the court, a technical breach case only. I'm going to come back to that and I'm going to show the court what Mr. Justice Briggs said in Sectorguard and indeed what this court said in Navigator last time round. The fifth point, which again I've spent time already on, and I won't elaborate any further, is the sheer fact of your lordships no doubt, of course, know a lot more about the law of contempt than I do, but in my own experience of contempt applications, this is one of the longest, if not the longest, contempt application in recent years, if not ever. On my own friend's analysis, it will inevitably go into a 6th year. And I repeat again, the vast amounts of legal expenditure on both sides that have been thrown at it, and the vast amounts of court time that has been expended on it. And that leads me to my final headline point, my lords, which is really going back to the first question I posed, which is what is the point of this appeal? It serves no private interest. Of course, most contempt applications in the commercial sphere have a coercive element to them. A person's ordered to do something, he or she refuses to do it, you issue a contempt application with the primary purpose and quite legitimate purpose of seeking to persuade the person who is in contempt to actually fulfil his or her obligations under the relevant order or undertaking. Now, there is no suggestion, nor could there be, that there is any private purpose or interest in that regard. Now, is there a public interest in it? Well, the way the matter was framed in the skeleton argument put before Judge Pelling by my learned friends back in March of last year was that what they said was, we are bringing this application to draw to the court's attention a serious breach, fulfilling some sort of self-appointed public function, apparently. Well, my question, but apparently. Now, the court then decided the question. It ruled on it. It decided that there was no breach. And if indeed Mr. Chanukin's intention was simply to draw to the court's attention a alleged breach, then presumably he would have thought, well, I've done my public duty, I've got my answer, I am content. But no, he appeals. Now, this point, the claimants are obviously sensitive to this point because they address it in their skeleton argument in this court. And what they say at paragraph 32 of their appeal skeleton is that the reason that they are pursuing this appeal is, quotes, well, not necessarily quotes, this is the sum of it, they are concerned to ensure that Mr. Deripaska does not breach court orders or undertakings in future in ongoing litigation between the Chanukin parties and Mr. Deripaska. That's apparently the reason they have brought this appeal, to stop, dissuade Mr. Deripaska from breaching future court orders in future litigation. Well, they don't identify what this litigation is. And I've asked, well, what is the litigation? What is going on between my client and Mr. Chanukin? And the answer is nothing. There are no extant proceedings between him and Mr. Chanukin or any of their avatars anywhere in the world, so far as I'm aware. There were some proceedings in Jersey which were brought by Mr. Chanukin concerning the Viscountcy and putting the shares in the Viscountcy name. So those were proceedings brought prompted by events of mid-2019. The order was made, of course, but that order's now withered on the vine because the matters have disappeared, because the money was paid and the undertakings were discharged. I understand no steps have been taken in that litigation for almost 2 years. And they serve no purpose that I can understand, and my learned friends choose not to elaborate on it. There are, of course, proceedings in this, there are costs orders in this country which have yet to be finally sorted out. But I can't imagine for a second that it might be suggested that we need a 2-day appeal to the Court of Appeal to ensure that Mr. Deripaska complies with whatever taxation, detailed taxation, or whatever order that might be made in respect of certain cost orders. So that's just not a credible answer or reason. It's also not credible, my lords, because is it likely that these proceedings are going to have a preventative effect vis-a-vis Mr. Deripaska in circumstances where he's now been labouring under these proceedings, having a penal proceeding hanging over him for 4.5 years, and with the expenditure of the millions of pounds that he's had to expend over the last 4.5 years in defending himself from these proceedings. It seems a somewhat narrow and flimsy foundation on which to justify this appeal. My lords, it is for those reasons, shortly stated, that I say this case has become disproportionate, and I'm going to just elaborate on a few of those points. But when I do so, that'll be doing good work in respect of other matters which I will come on to in due course. Now, my lords, I wanted to come on to the second aspect of that introduction and spend a little time on it, and that is the fact that the claimants themselves benefited from the acts alleged to constitute a contempt of court. And in order to make good that point, I need to spend a little time explaining what happened and going over some of the ground that my learned friend Mr. Crowe went over, but going over it from a different perspective, perhaps a fairer perspective, a matter for your lordships at the end of the day, of course. Now, my lords, we start with the fact that N+, the company at the heart of this case, at the time a Jersey company, was in 2018 the major shareholder in Rusal, which your lordships may know was at the time the second largest aluminium company in the world. But N+ was a lot more than simply a holding company. It provided power and employment to thousands of Russian citizens and power to millions of Russian citizens. And my lord, that is attested to by Mr. Deripaska at paragraph 20 of his affidavit number 5, supplemental bundle, tab 53, page 390. I do not need ask your lordships to go to it now. My lords, you know that in April 2018, Mr. Deripaska and N+, amongst other entities, were made the subject of US sanctions. Now, the result of that designation of that gentleman and those companies in that way was catastrophic. N+ faced an existential crisis as a result of that designation by the US authorities. Mr. Deripaska uses that precise phrase in his affidavit at paragraph 14, page 388 of the supplemental bundle. We will be looking at these in more detail, but I just don't want to go back and forth between it to save time. And that was not challenged in any way. He also says at paragraph 20 of his trial affidavit, and I quote, "I wish to make clear that I agreed to the above, i.e. the Barker plan, under what I regarded as severe duress, and in order to save N+ and protect the interests of hundreds of thousands of people working at its companies and millions of people living in Siberia and their families to whom N+ provides electricity." Paragraph 26, not challenged. He also said, so that's paragraph 20, not challenged. He also said at paragraph 26, "I considered and still do that my decision to support the Barker plan and the continuance was vital to securing N+'s future as a publicly traded company and to protecting the interests of millions of people. Conversely, I believe that had I not supported the Barker plan and the continuance, doing so would have been against N+'s interests and likely would have been fatally damaging. Fatally damaging. I believe the company would have been unable to continue as a publicly traded business, and the likely outcome would have been nationalisation." Paragraph 26 of his affidavit, not disputed. My lord, it's not just Mr. Deripaska saying this. The claimant's own position back in 2018 was precisely the same. If I can invite the court to pick up the supplemental bundle now at tab 1, go back to a letter which my learned friend took you to. We go to one final paragraph which he didn't show you. That's supplemental bundle, page 7, tab 1, paragraph 6, where Clifford Chance, solicitors acting for the Chinookan parties back in 2018, say this: "Unsurprisingly, it is clear that the sanctions are already having a devastating impact on Mr. Deripaska's business interests." So this is in real time. This is sent on the 16th of April, my lords, 19th of April, so 13 days after the designation. And we see at little a, b, and c quite how catastrophic the position was for N+ and for Mr. Deripaska. The share value in Rusal plunged over 50% 3 days after the sanctions were imposed. N+ lost roughly half of its value. I mean, for a company the size of N+, to lose half its value in the space of a few days, remember there's only 13 days have elapsed since the designation, on any view, catastrophic. That was the position being adopted by Mr. Chinookan by his solicitors on the 19th. And they never resiled from that position. And indeed, if one goes to Ms. Berard's first affidavit, this is tab 3, page 13. My learned friend showed it to you. This is the affidavit relied upon to obtain the worldwide freezing order before Mr. Justice Robin Knowles on the 11th of May. Ms. Berard at paragraph 9 talks about the significant direct impact on Mr. Deripaska's assets of the sanctions. And indeed, my lords, the package of evidence that was put before the court for the June hearing included an expert report from a gentleman called Mr. Haberman. We haven't looked at it yet. It's tab 12 of the same bundle. We can look at it very briefly indeed. Dated the 14th of June 2018. So just before the hearing, the second hearing before Mr. Justice Robin Knowles. And what was being said by Mr. Haberman, or rather by Mr. Knasiev of Haberman Eyelet, page 65, paragraph 23, is that the shares in N Plus were speculative. The value of the shares was speculative. Line 4, paragraph 23. And that was in response to the fact that at the time, and I think my Lord Justice Lewison may have asked some questions about this, the position of Mr. Chinyukin was undertakings related to M Plus were wholly unsatisfactory. He was refusing them and refused them doggedly up to the hearing. And we'll come on to precisely what happened at the hearing. I can take it quite quickly. My Lord, Mr. McGregor, in his affidavit for this application, returned to the question of the existential threat and catastrophic impact of the sanctions on M Plus in his affidavit. That's tab 36 of the same bundle. This is we don't have the first page, but which is a bore, but it's the affidavit served for this application, not an earlier witness statement. And at paragraph 27, page 208, Mr. McGregor, it's the first page, Mr. McGregor lays out, some of which we've already covered, the sheer threat that the sanctions pose to N Plus and Mr. Deripaska's other business interests. And one can pick it up at 27.1 and 27.2. I haven't got time to go through them. Now, so that's where things stand in April 2018. The likely outcome, as I will touch upon a little further in my submissions, was unless N Plus was able to delist itself from the SDN list, the US list, then there was, the likelihood was insolvency or nationalisation. I'm going to show you the evidence on that, but I don't want to take that quickly. Hence the imperative for N Plus and for Mr. Deripaska in April 2018 was to work out how to remove, or if it could remove itself, N Plus that is, from the list. And that imperative was in play well before the undertakings were offered and given at the end of June 2018. Now, if that existential crisis had come to pass, my lords, it would have necessarily had a profound impact on Mr. Chinyukin. Looking forward in time, i.e. to the period after the undertakings were offered and given, i.e. after the 28th of June, the shares which he says were to be preserved for his benefit in some shape or form, I'm using the phrase broadly, would likely have been rendered worthless absent the lifting of sanctions from N Plus. Now, had that happened, had steps not been taken to remove N Plus from the SDN list, and had insolvency or nationalisation occurred, then I quite accept Mr. Chinyukin might, whether legally or otherwise, have had quite a lot to complain about. The undertakings, the shares, would have been rendered worthless. Now, had Mr. Deripaska not done what we can see and we know he did do, then I have little doubt that Mr. Chinyukin's application to this court in November, or whenever it might have been in 2019, would still have been made. Contempt proceedings would no doubt still have been made, but for the precise opposite. i.e., it would have been said, you, Mr. Deripaska, failed to take steps to save N+, and therefore to save the value of my undertakings. Because as a result, I've got undertakings in an insolvent or nationalised company. And my lords, that takes me digressively, but importantly, to our additional ground 3 in our in the respondent's notice. And your lordships can pick that up in the core bundle, please, at, just to briefly take you to that, it's core bundle, tab 14, page 118. And the additional, it hopefully speaks for itself. For the Barker plan as defined in the judgment to proceed, it required the continuance to take place. I'm going to show you why that is, although it's not contentious. If the Barker plan did not succeed and N plus remained sanctions, the undertakers would have remained incapable of meaningful fulfilment because the shares would have had no material value, for the reasons stated. The sanctions would have prevented Deripaska from being able to pay the appellants as his assets would remain frozen. And 3B Finance would be unable to sell the shares because it was still they were listed on exchange and it was a sanctioned entity. And we say the undertakings have to be construed against those facts.
In order for the sanctions to be lifted, Mr. Deripaska's or B Finance's shareholding had to be diluted, I think. And
Exactly right.
And the only way to do that was to get the bank to agree the debt for equity swap. And it was the bank who said they would only do that
Exactly right.
if the company relocated to Russia.
I'm going to show you that your lordship has read ahead of me, of course, but the uncontentious evidence, it's vital to bear this in mind, this is not challenged, is that VTB was a creditor of N plus and other companies to the tune of, billions of dollars, and it had charges on some of the shares by way of security. The only way that B Finance could reduce its shareholding, and therefore Mr. Deripaska in turn reduce its shareholding in N plus, which was a requirement of OFAC, was to offload some of the shares. And of course, a lot of the shares were charged to VTB. So VTB basically were the power brokers here. And VTB, for whatever reason, as I don't know, it's not no part of my case to need to tell you, lordships. VTB said, we will only take steps that allow the Barker plan to succeed, i.e. to allow a dilution, if the continuance happens. It was VTB that demanded the continuance. Of course, it was voted on, and you know there was a vote in Paris on the 20th of December, but VTB demanded, I'm going to show your lordships this because my learned friend skated over it. I understand why forensically he skated over it. But just to finish off on ground 3, far from constituting a breach of the undertakings, the continuance permitted the undertakings to be fulfilled by allowing the Barker plan to occur, which was an event to the appellant's significant benefit. And the reason it was an event to the appellant's significant benefit was because, as opposed to having the benefit of undertakings in shares which had been rendered worthless because the company was insolvent, they had shares in a company which was thriving and surviving, and in respect of which everyone agreed the shares did not lose value post the continuance. Indeed, Judge Pelling, in a paragraph not challenged by these appellants, paragraph 70 I think it is, says that there's evidence that the shares increased in value. And in fact, I'm going to show your lordship where that evidence was. So the continuance was an ineffable benefit and good, not only to the employees of N+, not only to the denizens of Siberia, not only to Mr. Deripaska, but also to Mr. Chanuki, which raises the question, why on earth is he bringing and persisting in bringing this stale proceeding other than his loathing for my client? And I understand that that is not an impermissible motive because the Court of Appeal has told me that. But nonetheless, it is worth a point worth adverting to. Now, what is the answer to ground 3 that my learned friends seek to advance? My lords, it is set out in their secondary skeleton, their supplemental skeleton, I should say, which is at tab 16, core bundle, page 153. And that's where it starts. The submissions themselves are apparent page 156. And what they say is rather interesting. Para 9, additional ground 3 rehearses Deripaska's submission at trial that the redom of N plus was of benefit to the appellants because its effect was to preserve, enhance the value of N plus. The argument has no merit for the reasons given in judgment at paragraph 18. All that Judge Pelling said there is that if you have a problem, go back to court. Why don't you go back to court? So it's not an answer at all. The fact that the redomiciliation may have been in the commercial interests of N plus does not answer the question whether Deripaska acted in breach of his undertakings. Well, actually the point is rather wider than that. And that point is then grappled with at paragraph 10. Further, in any event, the fact that the redom may have improved the value of N plus was at most of peripheral interest to the appellants. And then this rather remarkable sentence, with the greatest respect, I suggest. They were not concerned with the underlying value of N plus, but rather with their ability to enforce against the shares referred to the undertakings. So they didn't care if the shares were worth nothing, so long as they could enforce against them. Well, the proposition only needs to be stated to be seen as fallacious and not nonsensical, with the greatest respect. Of course they were concerned with the underlying value of N plus. They were concerned to have shares which could be, in the event of non-compliance with the award after 42 days, after Mr. Justice Tier had agreed or not agreed with the Section 67 proceedings, in the event of non-compliance, could be sold. They wanted shares that could be sold to pay the award if Mr. Deripaska did not pay it. So I just simply can't comprehend what that sentence is designed to address. As explained in paragraph 16 of the appeal skeleton, the value of Mr. Deripaska's Russian assets was never in question. Moreover, the terms of the order dated the 19th of June, which embodied the undertakings, made express provision for the appellants to seek orders in respect of a larger portion. Well, that just proves the point. Of course, they were concerned about the value of the shares in cash terms. And if they fell below 87.5 million, then they'd go back, they had a right to go back and ask for some more. But the difficulty with the problem facing N plus was you don't just go half insolvent. You either go insolvent or not, or you don't go insolvent. And the evidence showed uncontestably and unchallenged that insolvency or Russian nationalisation was the likely outcome absent removal from the OFAC list. And if the company is insolvent, then all its shares are valueless or of highly impaired value, not just a proportion of them for obvious reasons. And then 11, in the circumstances, Deripaska's assertion that N plus would have become insolvent and or subject to state control, but for the steps he took or did not take, is beside the point. Well, it's profoundly not, with respect, beside the point. If it had become insolvent, then no doubt my client would be faced with a committal application making precisely the opposite proposition. And just finally, my lords, on this, footnote 4. For the avoidance of doubt, the appellants shall accept that the evidence shows that either would in fact be the consequence of the Barker plan failing. My lords, as I'm going to show this court, that was the consistent evidence, not only of Mr. Deripaska, but of a number of Russian witnesses who the claimants didn't even require to attend for cross-examination. And therefore, of course, on normal principles, their evidence is to be accepted.
Perhaps you can return to that in the morning.
Thank you, my lord.
10:30 tomorrow.
Thank you.
All rise at table.